Am I suspected of a crime?
There is a suspicion of the crime.
Am I suspected of a crime?
Yes, you are.
Okay, then I'm going to invoke my right to remain silent. If you want my ID, I will give it under threat of duress and arrest. That's it.
How you doing, sir?
Not bad.
Good. So you're taking photos, I gather.
I'm just out getting some video today.
Okay. Like I said, there's nothing wrong with that, right?
Right.
You know, nothing wrong with that. Did you have permission to take photos inside the store?
I was never in the store.
You are?
No.
Okay. Do you have your ID on you, sir?
Yeah, no, I don't.
I do have to have it because this is an investigation now because there's physical, that kind of thing going on. So that's why I have to have your ID, okay?
No. Am I suspected of a crime?
There is a suspicion of the crime.
Am I suspected of a crime?
Yes, you are.
Okay, then I'm going to invoke my right to remain silent.
Okay.
I'm going to let you know right now, everything that just happened was live on YouTube, and I'm live on YouTube right now.
Okay, I don't have a problem with that, sir. Not at all. Like I said, I'm videotaping too, all right? So, but this is an investigation, so I do have to have your
Investigate
ID
away, but you don't need my ID
Welcome
for that.
back, everybody. As many of you guys know, I'm a law enforcement trainer and instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, advanced criminal investigations, etc. And in this video, there's a lot of good talking points, a lot of good lessons learned. But the most important thing that I got from this video is just that I can impart on you guys is what would I do in this situation? You know, me as an active law enforcement officer, is me with, you know, advanced degrees in this stuff, somebody that trains law enforcement on constitutional law, somebody that studies constitutional law every single day. What would I do in a situation where I feel like somebody is wrongfully trying to violate my rights, right? In this video, we can clearly see that this little redheaded chick, at first she said there's no law being violated, then she states that she's detaining him and he has to compel and give ID. And, you know, how would I go about it? If this was me, if this was my person, how would I go about it? And let me just caveat this with, if you're a First Amendment auditor, you're not going to like what I have to say. You might as well just stop watching and just insert mean things in the comment section below, because this is obviously something that you're never going to do, because you are all about clickbait and you're all about trying to cause a scene, right? If that's you, it's just, again, log off now and go ahead and just, you know, put mean stuff in the comment section. If you're somebody that wants to survive the encounter, wants to go back home to their families, wants to safeguard their rights, this is what I would do. So the first thing I want to ascertain is, am I being detained, right? Texas v. Johnson, 1979, you guys know it. United States Supreme Court has affirmed that law enforcement needs what's called reasonable articulable suspicion of a crime in order to detain and compel someone to identify themselves. So the first thing I'm going to ascertain is, am I being detained? Yes or no? If I'm being detained, if I'm in fact detained, perfect. The violation pursuant to qualified immunity in Pearson v. Callahan 2009, we'll go over that here in a minute, has already been met. That burden of requirement has already been met for a lawsuit, has already been met for a complaint, has already been met for whatever it is that you want to do. The unlawful detainment, they said I'm being detained, no reasonable articulable suspicion, good. I've already got what I need from that standpoint. There's no reason for me to try to make a big scene for YouTube clicks. It's just, we're there. The next thing I'm going to say is, pursuant to in accordance with Texas v. Johnson and Torres v. Madrid 2021, I do not consent to any searches or seizures of my person or property. And again, am I going to, if you're asking me, are you actually going to state the case law? I absolutely am. I know it verbatim, and I'm going to give this dumb cop the rules to the test, right? I'm going to give them the open book test, because that's going to look great on body camera when we decide to go with whatever process we want to go with later. I'm absolutely going to utilize the Supreme Court case precedents, and I'm going to give them the answers to the test. Next, I'm going to state, I'm not going to stop you from violating my rights. If you wish to violate my rights, my wallet is in my back left pocket, which contains my state-issued driver's license and my credentials. 110%. I won't stop you from violating my rights. If you wish to violate my rights, my wallet is in my back left pocket, back right pocket, whatever pocket's at, which contains my state-issued license and credentials. Again, I'm stating I don't consent to searches and seizures. I've given them the applicable Supreme Court case precedents for it, because all the court cases we're talking about are Supreme Court case precedences. So again, I don't consent, but if you wish to violate my rights, I'm not going to impede you in violating my rights. Here's where my identification is. And then I'm going to say, based upon my training experience and for officer safety and for my own safety, I'm going to place my hands on top of my head and I'm going to interlace my fingers pursuant to in accordance with Terry v. Ohio, 1968. And then I'm actually going to do that 110%. I'm absolutely going to put my hands on top of my head, interlace my fingers. And again, I'm going to stay that way. And I'm going to rationale that with, based upon my training experience as somebody who trains and teaches defensive tactics, as somebody that trains and teaches case law, as somebody that trains and teaches patrol tactics, as somebody who is a law enforcement trainer, as somebody who does the advanced criminal investigative course for the state in which I'm in and certified in as an advanced certified police officer. I believe I have the training experience necessary to make that statement. And again, I'm doing it for officer safety and I'm doing it for the safety of myself. And I'm going to remain there. Then I'm going to state, given that you're using physical force to limit my ability to have freedom of movement, and due to the fact that I'm detained, I am now unambiguously invoking my Fifth Amendment right pursuant to in accordance with Burgess versus Tompkins 2010. 110%. And then guess what? After I invoke, I shut my mouth. There's nothing else left to say. 110%, nothing else left to say. Am I impeding this officer and violating my rights and getting my license? Absolutely not. Telling them exactly where it's at. And in fact, the safest way for that police officer to get my identification is not by me digging in my pocket. It's by having the officer do it if they in fact have the probable cause necessary to do what they need to do. Right? So if they have reasonable articulable suspicion to believe that I've committed a crime, they can absolutely get my identification. That would give them all they need to get into my pocket and take my identification from me. 110%. We are there. So, I say this because we're going to talk about qualified immunity here in a second. Pearson versus Callahan, 2009. Qualified immunity is a type of legal immunity that protects government officials from lawsuits alleging that the official violated a plaintiff's rights, only allowing suits where officials violated a clearly established statutory or constitutional right. Qualified immunity balances two interests. Number one, the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. So again, I am, by utilizing the case law, by giving them the test, I am mitigating both 1 and 2. One being that they have to exercise their power responsibly. So if they do it irresponsibly against case law, well, that would be bad. And then 2, we need to shield law enforcement and government officials from harassment and distraction and liability when they perform their duties reasonably. How can you perform your duties reasonably when I'm giving you Supreme Court case precedents that's showing that you're violating my rights? Again, that's why I use the Supreme Court case precedents, and that's why I quote it to them. And that's why I 100% put my hands on top of my head, I interlace my fingers, and I invoke my Fifth Amendment, and I stay shut up. Again, whatever they want to do to me, that's fine, but I know I'm not going to get a bad use of force, right? I know that I'm 100% in the clear. I know, again, everybody has their own opinion of law enforcement, but I've never seen a video where somebody quotes case law to a cop, puts their hands on top of their head, interlace their fingertips, says absolutely nothing, and they get shot or beat up. I haven't seen it. If you have it, please show me in the comment section below. Please send it to me via email, whatever. I want to know. I want to see it. Right? It just it doesn't. I haven't seen it yet. And so where people get in trouble, right, is when they fight with law enforcement, when they're trying to be antagonistic. They're just putting themselves in more unnecessary danger. And again, even if the officer's 110% wrong, I'm not going to put myself in more danger. I'm going to 100% stick to the Supreme Court case precedents. I'm going to 100% keep myself in a position where I'm not only safe, but I'm 100% covered. And if I want to reach out later and I want to go forward with 42 U.S. 1983 qualified immunity lawsuit or a complaint or whatever civil process I want to go to, I'm 100% there. Again, some FOP lawyer is going to get this body cam footage, going to be like, this guy seriously didn't read you Supreme Court case precedents, did you? Did this guy really tell you that he doesn't consent to searches and seizures, quoted case law to you, and said, I'm not going to stop you from violating your rights, and then read you more case law, and you still You still did it? Please tell me that this didn't happen. Please tell me this is a training video and this isn't real. That's what I want, right? Because I know what they're going to use. They're going to pull out their little FOP cards. They're going to call that lawyer and be like, I need you to do something because this guy's filed a lawsuit. And they're going to look at this and they're going to be like, he seriously didn't read that to you, right? Like that's a joke, right? He didn't do that. And then immediately, what I want, if I'm going to take it that way, go ahead. Give me what that deposit. What's that city deposit, county deposit, state deposit? Yeah, what's that insurance deposit you guys have? Yeah, go ahead and put a couple zeros on there for me. Appreciate you. So again, there you have it, guys. Again, there's no reason to be disrespectful. There's no reason to be rude. There's no reason to even be excited. There's no reason to be excited at all. I do this completely unexcited, unfazed. Go through the flow sheet, man. Go through the flow sheet. So there you go. Hope this video is helpful for you guys. But I'm curious. I'm really curious. What do you guys think in the comment section below? Tell me what you guys think about this. And again, I get it. If you're a First Amendment auditor, you don't care about efficiency. You want clicks and views. But for those of you that are logical minded, tell me what you guys think in the comment section below. As always, guys, long live the Republic.